A wage impairment is another way that we try to compensate injured workers after suffering an industrial accident under Section 8D1 of the Act. So a wage impairment comes into play when an injured worker suffers an injury, has a permanent restriction which precludes them from returning to their prior occupation. Because the law is designed to compensate an injured worker for a loss of an earning capacity, we look at wage impairments as a way to help do that. So if you get hurt and you can't go back to your former job, the question immediately comes up, is my employer going to accommodate these permanent restrictions? If the answer is no, the next question is, well, what can I do, if anything, and does it pay the same? If it doesn't pay the same, that's when a wage impairment will kick in. What we do is we take the difference in what you used to make prior to your accident and what you're capable of making with your new permanent restriction as a result of the accident, and you multiply that by 2/3. And then an 8D1 wage impairment will pay you that difference until the age that you're supposed to retire according to the Act at 67, or if you're about to retire and you're within 5 years of turning 67, then it will pay that benefit for the total of 5 years. So understandably, if you're a young worker that suffered a catastrophic injury which precludes you from returning to your former occupation, these cases can be worth a pretty substantial amount of money because we're talking about a lifetime of wages. Whenever you have a permanent restriction which precludes you from returning to your prior job, you should immediately be thinking, am I a candidate for an 8D1 wage impairment?